SwayamPrabha. Digital India. Educated India.
Hello friends, you all are welcome in session number 8 to the course Law Relating to Women and Children. In the present session, I have come with the topic Care and Protection of Juveniles in India. This is the topic relating to the care and protection of juveniles, and therefore, at very outset of our discussion, we must know about two terms. Number one, the juveniles, and number two, the juvenile justice. The term juvenile refers to a person who has not achieved the maturity or who cannot be said to be an adult. So, any person who is below the age of majority or who is minor, he is known as juvenile. The other names for juvenile may be the youngster, the young people, the child, or the minor. Juvenile justice refers to the system of law or any process or any procedure which is intended or which is aimed at taking care of the protection of juveniles or the treatment of the juvenile offenders. When any juvenile violates the law, for violations of the law by the juveniles, the juvenile justice system makes the treatment. So, the treatment of juvenile offenders, and in addition to the treatment of juvenile offenders, the care, protection, rehabilitation, all are aspects of care and protection of such young people who are either in conflict of law or who are neglected persons. This whole aspect is covered by the juvenile justice system. So, the juvenile justice system refers to the care and protection of juveniles. Either the juveniles are the violators of law or they are in conflict with the law, or the juveniles may also be the neglected persons or neglected children. And therefore, the topic or the subject of juveniles or the care and protection of juveniles is as important or significant as the care and protection of early childhood. And therefore, each system of law or each country or each nation should be very cautious about developing the precise system, an effective system, a sound system to make the treatment with the juveniles. In India also, this system has been evolved as per the mandate of Indian Constitution or as per the international obligations of Indian state in various international agreements or conventions relating to children. And therefore, in this lecture, we will discuss all these aspects. What is the meaning of juvenile? What is the juvenile system? What is the objective of juvenile system? And then, what are the international initiatives with regard to the care and protection of juveniles? Then, what is the constitutional mandate for the protection of juveniles in India? Then, what is the legal framework or what laws are enacted in India to take care of the juveniles or to treat the juvenile offenders or for the care and protection of juveniles, either these are in conflict of law or these are the neglected persons. We can start with the statement of Professor Colin In his book Criminal Law, which was published by Law Book Company in its 4th edition at page number 343, he states that no civilized society regards children as accountable for their actions to the same extent as adults. The wisdom of protecting young children against the full rigor of the law is beyond argument. The difficulty lies in determining when and under what circumstances should it be removed. So, the justification behind having the juvenile justice system, justification behind treating the juveniles with some distinctive measures or with the distinctive law, that justification lies in the statement of Professor Colin Howard. He says that no civilized society regards children as accountable for their actions to the same extent as adults. And it is certainly true, it is correct that the a child cannot be treated equally with an adult even for the violation of law, even for any action or any offence being done by such a child. And in this statement, the justification as I told you, that the justification to have the distinctive procedure, to have the distinctive laws, to have the distinctive system to treat with the juveniles lies. And therefore, the juveniles must have, or they are entitled for the distinctive treatment on the part of states, even if they are making any crime or they are violating any law. For the violation, for any incidence of violation of law or for any crime on the part of juveniles or children or youngsters, they cannot be treated equally with the adults, and therefore, the law needs some different system, and this system is known as juvenile justice system. Friends, the law relating to juvenile protection is an extremely contentious area and sensitive issue also. Therefore, it should be treated with maximum caution and care. Earlier, the law relating to the commission of crimes by the juveniles was under a predicament, but nowadays, with the evolution and development of the law at international and national both the levels, it has become more detailed, clear and precise. Juvenile justice system is a more delicate and sensitive area of law because it deals with the rights, care and protection of children, and several legislations and legal instruments have been adopted at national or international both the levels. Juvenile justice system is a jurisdiction which deals with various issues including the rights, freedoms, care, protection of adolescents and the social, interactive, collaborative and behavioral aspect of the life of youngsters. So, this is also one important objective of juvenile justice system, to make the social reintegration of those children who for any reason are violators of law or who for any reason have committed the crime, have committed the offence, and social integration of or social reform of such children is very necessary for the society itself and for the nation also, because children are the future assets and they cannot be the care and protection of such children cannot be compromised, they cannot be left for their own fate. Certainly, the state should intervene for the social integration of, because many times we see that it may not be possible for the society or the family alone to make the social integration of or social reintegration of such children who for any reason have involved in any crimes, offences or who are the violators of law. So, social integration is also one aspect of juvenile justice system. The term juvenile refers to any person who has not reached to the age of majority. It means that a person or a child who is not as old as to be considered as a mature or an adult may be called as juvenile. This is because the law fixes the criteria for determining a juvenile varies from jurisdiction to jurisdiction. The general consideration for determining the age of the juvenile or majority is 18 years. But in countries like Japan and Taiwan, the consideration is 20 years. So, it differs from jurisdiction to jurisdiction what age of majority should be fixed by law. It is very important to say that when the juvenile is a person who has not achieved the age of majority or who cannot be considered, who cannot be said to be a mature person, an adult person, then again the justification lies in this meaning of juvenile that they should be given some relaxations, they should be given some exemptions for any punishment or for any treatment when they violate the law. In the criminal law area, we all know that even in Indian Penal Code and in the criminal law of other jurisdictions like US, like UK, there are the exemptions for the children or for the persons who are not major or who have not achieved the majority. For any crime, the punishments are being prescribed at different footing for both for an adult and for a child. And therefore, again the justification lies behind the separate system of justice for the juveniles, and therefore, the concept of juvenile justice was evolved. When the child is given the exemption, when the child is given the relaxations in the law, then certainly it is because of the reason that in the area of criminal law, we know that the mens rea or the intention, the intent of a person is very determinative factor whether the person has committed the crime or not. Whether any person can be punished under the criminal law or not, whether any person can be said to have committed the offence or the crime or not, it depends on the very precise factor or the element of crime, that is the mens rea. If all the actions have been done by a person which constitute that crime, but his intent is not existent, or the intent or the intention of that person is not found, then that person cannot be punished with the same degree of punishment with which the other person would be punished who have the intent to commit the crime. And therefore, the intention is, which is called in the language of criminal law as mens rea, that mens rea or the intention of a person is the determinative factor or very fundamental element of crime, and therefore, we cannot say that a child who is not major, who is not adult, who has not the proper understanding what he is going to do, how can he punished at par with the other persons who are mature, who have the understanding when they are going to commit any crime, they are committing the crime with the intention. And therefore, the juveniles or the children are, for this reason also, they are entitled for having the different system for their treatment. Friends, according to the United Nations Standard Minimum Rules for the administration of juvenile justice, these are also called as Beijing rules. A juvenile is a child or young person who, under the respective legal system, may be dealt with or an offence in a manner which is different from an adult. So, according to the Beijing rules also, a juvenile is a child or young person who, under the respective legal system, in a country, in a legal system, in a jurisdiction may be dealt with for an offence in a manner which is different from an adult. As discussed earlier, the juvenile justice is within the domain of criminal law, which deals with the offences committed by juveniles, and it is also provided for their behavioral aspect, liberty, rehabilitation and penal implications. These are the different aspects of juvenile justice system. The aspects relating to the behavior of the juvenile, the child, the liberty or the freedoms of the juvenile, the rights of the juveniles, the rehabilitation and the penal implications. These are the different aspects to be dealt with by the juvenile justice system. Prior to the introduction of juvenile justice system, youngsters were tried and punished for the offence committed by them in the like manner as the adults. When this juvenile justice system was not discovered, the juvenile justice system was not evolved, or it was not thought that the juveniles must be treated with some distinction with the adults for the crimes or for the offences or in the field of criminal law. So, prior to the introduction of juvenile justice system, prior to the introduction of distinctive system of law to treat the juveniles were also being treated at par with the adults. But with the evolution of legal system based on juvenile justice, a distinction was drawn between the offences committed by adults and the juveniles. Another term used in the area, that is juvenile delinquency, juvenile justice and the juvenile delinquency. This juvenile delinquency, which refers to the commission of an offence by a juvenile. With the development of law concerning juveniles, the method in which a juvenile is treated is different from that of an adult. So, juvenile delinquency means the commission of an offence by a juvenile. According to James Werfend and Don Jeglum Peters, juvenile delinquency means actions that violate the law committed by a person under the legal age of majority. So, juvenile delinquency refers to the crimes or the offences or the violations of law being committed by a person who is below the age of or who is under the age of majority. The distinctive treatment with juveniles and adults with reference to the commission of an offence is made because of the fixation of minimum age of criminal responsibility in the area of criminal law and the doctrine of Dolly in caps. These are two important aspects. In all the jurisdictions in the area of criminal law, the certain age has been fixed for making any person responsible to commit the crime. The age has been fixed that on such a age, on the achievement of such age, a person would become capable of understanding the nature of the act which he is going to commit. And unless and until a person is not capable of understanding the nature of the act which he is going to commit, how that person can be held responsible at par with those persons who are capable of understanding the nature of the act which they are going to commit or which they are committing. This is the justification, or this is the reasonable classification between two groups. One group belongs to those persons who are not having the understanding or who are not having the capability to understand the nature of the act, and others who properly, sufficiently know the nature of the act which they are committing. And therefore, the age has been fixed, that this is the certain age on which, when the person acquires such age, then the law will presume that he or she understands the nature of crime. So, this is one aspect on which the distinction is made for any crime being made or for any violation of law being made by a juvenile and by an adult person, that there is always the fixation of a certain age for the criminal responsibility. And another doctrine regarding this is doli in capax. The doctrine of doli in capax is a Latin phrase and it means incapable of causing harm or committing a crime. The doctrine supposes that a child is not capable of forming the required criminal intent to commit an offence. The doctrine supposes that a child is not capable of forming the required criminal intent to commit an offence, and therefore we see that in criminal law the persons having mental incapability or who are mentally incapable to understand the things, they are exempted from the liability of crime, and likewise the children also. The age of criminal responsibility differs from country to country. For example, it is 12 years in Canada and Netherlands, whereas it is 7 years in UAE and in India also. It is also not necessary to specify a specific age for criminal responsibility, and therefore, in some jurisdictions it has been left for the prosecution to prove the existence of criminal intent. If the age has not been fixed, then it is the responsibility of the prosecution to prove the intention of that person on the it is the responsibility of the prosecution to prove that or to establish that that person was knowing the consequences of the act which he committed, and therefore the Beijing rules provide for taking suitable initiatives to make it reasonable, rational and even handed. Because there is the discretion of the jurisdictions or legal systems, they may have any certain or precise age limit for the criminal intent, for assuming or presuming the criminal intent, or they may not have such, or they may not prescribe the age limit for presuming the criminal intent. They may leave this for the prosecution to determine whether the person was capable of understanding the nature of or the consequences of the act which he committed. This is the reason for which the Beijing rules directs that, or Beijing rules advocated that in all the jurisdictions that should be made on the ground of reasonability, on the ground of rationality, because this is very sensitive issue on the basis of which even a child can be punished at par with the adults if there is any flaw in the law or in the process, in the procedure to determine the age of the criminal intent, and therefore the Beijing rules were of the opinion, or Beijing rules provided that determination of the age must be reasonable, rational and even handed. The most critical and difficult element in the area of criminal justice system, as I told you, is to constitute and interpret mens rea, the criminal intent or the criminal intention to commit an offence. Juvenile and an adult are treated on different footings as to judicial procedures, mainly due to this conception. This is also the reason that most of the legal systems follow the doctrine of doli in capax, and the juveniles below the particular age are excluded from the liability to some extent for the commission of an offence. Though the area of juvenile justice system could not become the area of focus, attention and much significance until the late 19th century, but now it has become an area of priority and significance in the field of law. It contains number of national legislations and international legal instruments across the globe. The international law on juvenile justice focuses on different issues of juveniles and has offers the measures to protect the interest of the juveniles against the abuse of law. With the increase in concerns relating to child protection and their rights, many countries have adopted measures within their legal framework to safeguard the interest of juveniles. In 2005, in the case of Roper versus Simmons, the American Supreme Court found the accused guilty and punished with death penalty. In this case, a person naming Simmons, aged 17 years, decided to break and enter a lady's home and murder her. He, along with two of his friends, prepared a plan for the commission of this crime, but one of his companions left the plan before a day. Simmons and one of his friends broke into the victim's home, bound her hands and threw her over the bridge. That was the crime committed by the person aged 17 years. The Supreme Court of US found the accused guilty, but in 2015, the Supreme Court of United Nations held that it is unconstitutional to impose the death penalty on the person under the age of 18 years, and accordingly overruled its earlier judgment made in the case of Stanford versus Kentucky. This Roper versus Simmons case was decided on the basis of the judgment in Stanford versus Kentucky. The Supreme Court of United States in 2015 decided that below the 18 years, the death penalty cannot be imposed or the death penalty cannot be given to a person. The person below the age of 18 years cannot be punished with the death penalty. This was the decision of the Supreme Court of US, whereas in earlier case, the person aged 17 years was found guilty by the American Supreme Court. So, after 2015, after this decision by the Supreme Court of US, now it is established in America that a person below the age of 18 years cannot be punished with death penalty. If we see the development of international law with regard to the care and protection of juveniles, we will find several international initiatives on the part of international community, on the part of the United Nations, on the part of different commissions or the committees under the supervision of the United Nations. In this regard, we can refer to Article 6(5) of International Covenant on Civil and Political Rights 1966. The first document which we see with regard to the care and protection of juveniles seems to be the International Covenant on Civil and Political Rights. See Article 6, Clause 5 of this covenant. It says the sentence of death shall not be imposed for crimes committed by persons below 18 years of age and shall not be carried out on pregnant women. So, death penalty cannot be imposed on the persons below 18 years age and on pregnant women, Article 6, Clause 5 of International Covenant on Civil and Political Rights. You can see that in 1966, when the ICCPR was agreed to by the international community by different countries of the globe, then they decided that all the jurisdictions, they were agreed to on the point that the persons below the 18 years should not be given or should not be imposed or should not be punished with the punishment of death penalty, and the pregnant women should also not be. Here at this point of discussion or in this lecture, we are concerned only to the juveniles or the persons below the age of majority, and therefore, this aspect of or this portion of Article 6 Clause 5 of ICCPR is relevant to make the distinction between the juveniles and the adult offenders or adult criminals. Then Article 14 Clause 4, in the case of juvenile person, the procedure shall be such as will take account of their age and desirability of promoting their rehabilitation. It means that the juveniles cannot be only punished by the law. In addition to the punishment, the concerns about their rights, concerns about their rehabilitation, concerns about their development, concerns about their social integration or social reintegration, and concerns about their future life, the concerns about their role in the society in future should also be taken into consideration at the time of prescribing the punishment, at the time of prescribing for the procedures to treat with the juveniles or to treat with the offenders below the age of majority or the youngsters or young persons. This social integration or this care and protection aspect of the juvenile justice system is also very relevant or significant with respect to the theory of social reform. In the criminal law, in area of criminology or in the area of criminal law, where the different theories of punishment have been evolved. Within those theories of punishment, there is one theory, that is deterrent theory, where the very stringent punishments are given. Death penalty is the example of that. The application of that deterrent theory of punishment. And in addition to deterrent theory or other theories, one theory is known as social reform theory. And the persons who are contained in the jails, the reformative procedures are adopted for making the reforms of those persons who are for any reason have been found involved in any crime. So that by making the reforms or by reforming those persons, they can be made capable of participating in the society, capable of playing their role as the responsible person in the society. So it is being done with the adults also, and therefore the children or the juveniles who don't have criminal intent, they are certainly entitled for any such rehabilitation process or any such initiatives for their care, protection, rehabilitation and social integration. Then Article 24, it is also important. Article 24 say that every child shall have, without any discrimination as to the race, color, sex, language, religion, national or social origin, property, worth, right to such measures of protection as are required by his status as a minor on the part of his family, society and the state. So, being the minor, they have the right. Every child shall be registered immediately after birth and shall have a name. Every child has the right to acquire a nationality. So, these are the important aspects of the ICCPR. Then the next instrument which is very relevant for this purpose is the United Nations Standard Minimum Rules for Administration of Juvenile Justice 1985. This is the international initiative, this is the international procedure or the rules which have been adopted to deal with exclusively with the juvenile justice, and therefore these are very relevant for our discussion. the United Nations Standard Minimum Rules for the Administration of Juvenile Justice 1985. These rules were adopted as a means to fortify the juvenile justice system across the globe. According to the Rule 5, the main objectives of these rules are as follows. See the objectives. The juvenile justice system shall emphasize the well-being of the juveniles and shall ensure that any reaction to juvenile offenders shall always be in proportion to the circumstances of both the offenders and the offence. The fundamental principles of this international instrument are stated in Article 1 as fundamental perspective, which are as follows. So, objective is found in Rule 5 and the fundamental principles are found in Article 1. The well-being of the juvenile and his or her family is the fundamental principle of these rules. A juvenile must get suitable conditions to lead a meaningful life in a community that is free of crime and delinquency. Positive measures to be taken to give full access to resources to the juvenile to promote his well-being by dealing with the case in a humanely, fairly and effective manner. Juvenile justice must be an integral part of country's national development. The member states should ensure the implementation of these rules concerning the economic, social and cultural conditions prevailing in their nations. Juvenile justice services shall be systematically developed and coordinated to improve and sustain the competence of personnel involved in the services, including their methods, approaches and attitudes. It has been provided by Rule 7 and Rule 8 that following rights shall be guaranteed to the juveniles at every stage of proceedings. Number 1, basic procedural safeguards such as presumption of innocence. This is the basic or fundamental principle in the area of criminal law, that criminal law always presupposes, criminal law always presumes, the criminal law always assumes the innocence of the accused. The presumption of innocence is the fundamental policy, fundamental law of criminal law. Whole the system of criminal law is based on this fundamental principle, that there is a presumption of the innocence. When presumption of innocence is there, it means in other procedures we find that if any suit is filed in the area of civil law against any person, then that person or the respondent himself or herself is required to establish the allegations made by the plaintiff as negative or to disprove those allegations. But in the area of criminal law, if the prosecution prosecutes any person, then it is not the responsibility of accused to prove his or her innocence. This is the presumption. The law presumes the innocence of that person or the innocence of accused, and the prosecution is to prove the person as guilty. Prosecution is to prove the allegations made by it, and that person is not to contradict those allegations. There is always the presumption of innocence, and therefore the right to presumption of innocence has also been given by these rules to the juveniles. Number 2, the right to be notified of the charges. This is also the basic of the procedural law, or it is also the part of principles of natural justice, that right to notice should be there, or the person must be given the notice. Without giving the notice, nobody can be punished. So, right to notice is also one aspect of procedural law, and the juveniles are also entitled to this basic rule according to the Beijing rules. Then, right to remain silent. Right to remain silent is also the right of the juvenile during the procedure of the court. Then, right to counsel. right to legal representation, right to be represented through lawyer. This right has also been recognized by these rules. Right to the presence of parent or guardian, because the juvenile is not the mature person, and therefore at the time of any such procedures there is the right of the juveniles to have the presence of their guardian or to have the presence of their parents. Right to appeal to the higher authority or to the higher court is also given to the juveniles. Right to comfort has also been recognized by these rules. Right to privacy has also been recognized by these rules. Then under rule 4, the guidance was given for fixing minimum age of criminal responsibility, and according to it, the beginning of that age shall not be fixed at too low an age level, bearing in mind the facts of the emotional, mental and intellectual maturity. So, very low age should not be fixed as the age of criminal responsibility, and these aspects, the emotional, mental and intellectual maturity of the child should be taken into consideration. Rule 10 provides for the guidelines as to the prosecution of the juveniles. Then rule 12 provides for that in order to best fulfill their functions, police officers who deal with the juveniles or who are engaged in the prevention of juveniles criminality shall have special knowledge, skill, expertise and training in juvenile matters. In addition to this, in big cities, special units of police and administration should be established for that purpose, and this is also very important initiative on the part of Beijing rules. Rule 13 enunciates that the detention pending trial shall be opted as the last option. The detention of juveniles should be the last option, because if they are mixed up with the other offenders or habitual offenders or the adult offenders, then the criminality may develop in their mind, and therefore the detention should be the last resort, and if the detention is necessary, then it is also the recommendation of Beijing rules that that detention must be separate from the detention homes or the jails where the adult offenders or where the habitual offenders are contained, and therefore the separate detention should be there. Rule 14 provides that the competent adjudicatory authority shall deal with the juvenile in according to the principles of a fair and just trial, and the proceedings shall be conducive to the best interest of the juvenile and shall be conducted in an atmosphere of understanding which shall allow the juvenile to participate therein and to express herself or himself freely. Rule 17, the reaction taken shall always be in proportion not only to the circumstances and the gravity of the offence, but also to the circumstances and the needs of the juveniles as well. So, the doctrine of proportionality has been included within the rules by rule 17. According to doctrine of proportionality, the punishment must always be in proportion to the nature of crime, in proportion to the amount of crime, in proportion to the nature and circumstances of crime. So, it has been provided or recognized by the Beijing rules that the doctrine of proportionality should be accepted or adopted at the time of awarding the punishment to the juveniles. Each case shall from the outset be handled expeditiously without any unnecessary delay according to rule 19. Records of juvenile offenders shall be kept strictly confidential. Rule 21, and then professional education in service training, refresher courses and other appropriate modes of instruction shall be given to all personnel to make them competent in dealing with the juvenile cases. Juvenile justice personnel should be from diverse areas, and efforts shall be made to ensure the fair representation of women and minorities in juvenile justice agencies. Then the United Nations Guidelines for the Prevention of Juvenile Delinquency 1990. It is also known as Riyadh Guidelines. These also provides for certain measures to be taken into account for the prevention of juvenile delinquency, so that the juveniles may not be punished or may not be treated with the criminal law. You can see the fundamental principles of this international instrument. The United Nations Secretariat plays a significant role to coordinate or cooperate the interested institutions and assist them in conducting research, bringing about the scientific collaboration for formulation of policy, the review and monitoring of the implementation of policies based on the Riyadh Guidelines. United Nations Guidelines for Action on Children in the Criminal Justice System is also one international initiative. The International Juvenile Justice Observatory was established in 2002, and it focuses on the rights of children and adolescents at risk of social exclusion. Then the Indian law, that is Juvenile Justice Care and Protection of Children Act 2015, is the union legislation in India to deal with the juveniles. We have discussed the international aspect, international initiatives, and some constitutional aspect also, wherein in different cases the Supreme Court talks about the ways or the procedures which should be there in the juvenile justice system, and what are the rights of the juveniles or the children which were to be taken into consideration at the time of treating the juveniles. Now see the provisions of the Juvenile Justice Act. By the name of this act, in short, it is called as Juvenile Justice Act, but at the time of giving the title to the enactment, the Parliament or the legislature made it clear that this Juvenile Justice Act is aimed at the care, protection of the children. According to the objective clause of Juvenile Justice Care and Protection Act 2015, the act is to provide for proper care, protection and handling of the children in need of care and protection. The children in need of care and protection are defined in section 214 by serving the basic needs for their development and espousing a child-friendly perspective. This is the objective of the act. For this purpose, the section 213 and section 214 of the act distinguishes between two groups of children: children in need of care and protection 1 and the children in conflict with the law. These are the two groups of juveniles or the children or youngsters we are to be treated by this enactment. The former, the children in need of care and protection, the former comprises the children who are in adverse conditions and are in need of state support to become responsible citizens, whereas later are the children who are involved in criminal activities. The state is obliged to constitute for each district one or more child welfare committees to exercise the powers conferred and to discharge the duties assigned by the Act under section 27 subsection 1. The committee is the final authority to determine the cases relating to care, protection, treatment, development and rehabilitation of the children. It is also obliged to provide for their basic needs and protection of human rights under section 29(1). Then Section 31 clause 1. According to this provision, a child who is in need of care and protection is to be produced before a committee by any person designated by the Act within the period of 24 hours, and a report shall be prepared and sent to the police and to the committee. So, any person designated under the Act should produce such a child who is in need of care and protection before the committee, and committee shall prepare a report, and that report shall be sent to the police and the committee. The report shall also be made by the person concerned. On the production of child or the receipt of report, when the committee receives the report or the child is produced before the committee shall make an inquiry and issue an order to send the child to the children's home or a fit facility or a fit person to stay pending the inquiry. During inquiry, that child will be sent to the children home or to any fit facility or to any fit person, or to stay for his or her stay pending the inquiry. This is provided in section 36(1). On the basis of conclusions drawn in the inquiry, if the committee finds that the child has no family or support or is in need of continued care and protection and is below the age of 6 years, the child shall be sent to a specialized adoption agency. If he is or she is below the 6th year, then he shall be sent to SAA, Specialized Adoption Agency, according to section 36, subsection 3. This Specialized Adoption Agency helps to facilitate the process of adoption for the children in its institution and children in the child care institutions linked to the SAA. It also has the responsibility to provide care and protection to every child in its institution. Chapter 7 of the Act is devoted to the matters of adoption, which provide for complete and efficient mechanism to streamline adoption of orphan, abandoned and surrendered children. Orphans, abandoned children and surrendered children. Under section 68 of the chapter 7, the Act constitutes the Central Adoption Resource Authority, that is CARA. For replacing earlier Central Adoption Resource Agency, in place of this agency, the CARA has been established. The Act also provides for establishment of State Adoption Resource Authority, that is agency, that is SARA. So, at central level, the Central Adoption Resource Authority would be there. At state level, the State Adoption Resource Agency would be there to deal with the matters relating to the adoption in the state under the supervision of CARA. The CARA has been constituted with an objective to promote in-country adoptions and to facilitate inter-state adoptions in coordination with the state agency, to regulate inter-country adoptions, to frame regulations on adoptions and related matters, to take care of its responsibilities arising from Hague Convention on protection of children and cooperation in respect of their inter-country adoption. It has been made mandatory that all inter-country adoptions shall be made exclusively in accordance with the provisions of the Act and the regulations of CARA. The Act shall not apply to the adoption of children under Hindu Adoption and Maintenance Act. So, all these are the provisions relating to the adoption. Section 56(3) and 56(4) leads to the conclusion that if we read these two sections together, then we lead to the conclusion that all inter-country adoptions, irrespective of their religion, are required to be made in accordance with the procedure of the Act. Though it is not applicable to the Hindu Adoption and Maintenance Act, but for international adoptions, it is applicable to all adoptions irrespective of religion of the person. Unlike earlier act, the present act makes the registration of child care institutions as mandatory requirement. It is very important initiative. Proper inspection of the institutions established under the act is also stipulated by the inspection committee appointed by the state government. It has been made mandatory. Then the Juvenile Justice Care Protection and Children Act, where all these initiatives have been taken, and for proper care protection of juveniles is made for both the procedure as to the treatment of juveniles and the care and protection by way of the children's home, by way of the fit facility, by way of fit persons, by way of the Kara and Sara relating to the adoption of such persons. It is also important to know that the act lays down criteria for prospective parents for adoption, which was lacking in earlier act. This provision may help in speeding the adoption process. Monthly visit by Child Welfare Committee to foster family has been included in the act, and therefore it seems that the act adopts all those standards and norms or all those principles and perspectives which have been recognized by the international community through different international initiatives. If the proper implementation of this act is made, that may be very good initiative on the part of government to take care and protection of the juveniles in India. Thank you very much.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar, and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.